Hello and welcome to the new series of Drishti IAS. I am Pooja Dwivedi, and in this segment today we are going to discuss about phone tapping in India. From the perspective of preliminary examination, you will have to be careful with the facts and the concept of phone tapping, the authorized agencies and relevant laws. Very important from the perspective of prelims and mains both. From the perspective of mains specifically, challenges and solutions are important. So let's begin with the news. Now, Shiv Sena leader Sanjay Raut has accused the Center of Protecting IPS Rashmi Shukla, who is now with the CRPF, that she is being protected by the center. Rashmi Shukla is allegedly involved in tapping the phone of Rajya Sabha MP Sanjay Raut and NCP leader Eknath Khatse in 2019 when she was employed with the Intelligence Bureau of Maharashtra government. Now, this makes us to critically analyze the concept of phone tapping in India, the relevant laws and agencies, and what are the challenges as well as the solutions to this particular issue. Let's move on and talk about a definitive statement or a definitive information about phone tapping. What is phone tapping basically? Phone tapping is the activity of secretly fitting a special device to someone's phone in order to listen to their phone conversation without being noticed. Now, it does not only involve a special device, it could be done with the help of service providers in the digital era. Why do I say so? Because this particular era is of digital system, and in the times of fixed line telephones, these were done by mechanical exchange or telephone exchange, which used to have circuits together, and through these circuits a proper conversation recording could be done. But now, if we talk about the digital era, the service providers play an important part. So, authorities, whoever want to gain access, they have to make a request to the service provider, and it is bound by law to record the conversation on the given number, okay, and provide these real time through connected computers, okay. So, these authorized agencies, whenever they, of course, which are legitimized by a legislation, a law or an act, they have to ask the service provider. They will provide the relevant information with respect to the given number and in real time. That means at the time it is happening, at the time I am having a call, that in that basic time, that information or the conversation should be provided at the immediate level, and that is through the help of connected computers. Okay, so here the question arises, who all are authorized to have access to such a step? State police first, at the central level we have 10 agencies, Intelligence Bureau, then CBIO is also there, Enforcement Directorate is there, Narcotics Control Bureau, along with Central Board of Direct Taxes, Directorate of Revenue Intelligence, National Investigation Agency, Research and RAW, Directorate of Signal Intelligence, and the Delhi Police Commissioner. So apart from these agencies, no other agency has the legitimacy to ask for phone tapping. If in case there is an emergency, there is also another process that people can have an access, people as in the, of course, important authorities can have an access to phone tapping. In case of emergency, we see that an officer not below the rank of a joint secretary to the government of India can give the authority with respect to having phone tap. Or in case if supposedly there is an information which needs to be recorded, which needs to be accessed, but it is not connected to the competent authority. Suppose this person is not present because the information is in some remote area, then what will happen? Then the person, the authority who is legitimized to do so is the second senior most officer of the authorized law enforcement agency at the central level, and by authorized officers at the not below the rank of, remember this is important from the perspective of prelims, not below the rank of IGP, that is Inspector General of Police at the state level. Now here the most remarkable example that I can give you is the 26/11 attacks in Mumbai. And there is another procedure. The procedure is very written in nature. because whenever an access is needed to the phone tapping, a written letter should be provided to the service provider. Then only the phone tapping will be made available. In 26/11 attacks, when there was no other option or no proper protocol or procedure could be followed, then the agencies, they asked for surveillance on the terrorist's phone by the service providers of Intelligence Bureau. This was done through a mail. And after that, the proper authorization was done after that that approval was given. Because of course, how could we do so? How could the police department do so? Not having any proper procedure to be followed, they had to do it. So this is one of the things. Another thing, we have to know that prelims is important. This question is important from the preliminary facts. That is why this is the prelims alert. Answer this correctly. Under whose Governor Generalship was the Indian Telegraph Act, which still governs India's surveillance procedure, passed? Okay, so Lord Dufferin, Lord Cornwallis, Lord Bentinck and Lord Lytton is the option. Answer it correctly. And the relevant law with respect to this particular segment is, or phone tapping, is the Indian Telegraph Act of 1885. Section 5 clause 2 has talked very openly about when to have a tapping access to the wired or wireless technology, that is on the occurrence of any public emergency, if there is any public emergency, or in the interest of public security or safety. Public safety, sovereignty, integrity of India, security of the state, as well as friendly relation is also important from the perspective of having legitimacy with respect to phone tapping. This is important from the perspective of prelims, and that is with foreign states. Also, it takes into account public order or for preventing incitement of a commission of offense. Now, these are very open-ended terms. This is one of the issue with respect to the Indian Telegraph Act. So open-ended term, no definition with respect to what is public safety, no definition or set lines with respect to what is public order, what is friendly relation with foreign states. So these are the certain open-ended terms which give this particular act the disadvantage of being criticized. Now, press is an exception here, because here it is being said that press messages intended to be published in India of correspondence accredited to the central government or the state government shall not be intercepted unless their transmission has been prohibited under this subsection. Now, this also gives a lot of power to the surveillance state to have a picture in mind that what is prohibited or not, what is not prohibited is not defined again. So that is also another problem. Press can also come under it. And the reasons for tapping are given in writing. Rule 419A of the Indian Telegraph Amendment Rules of 2007 shall not be issued except by an order. Now, who can authorize it? Except by an order made by the Secretary to the Government of India in the Ministry of Home Affairs. Very important prelims fact. Remember this. It's not Ministry of Defense. It's not Ministry of External Affairs. It's not any other ministry, not even Ministry of IT, okay, Electronics and Information Technology. No, it's Ministry of Home Affairs, because security is the very important part of Ministry of Home Affairs. Necessary information by other means. Here it means that 419A also suggests that if there is any other means of getting the necessary information other than phone tapping, that should be exhausted, and phone tapping should be the last resort. It should, whatever information that is to be given in writing for having phone tap, for having any person's phone tapped, should have a written consent with respect to important contents. What is the reason? Copy is to be forwarded to a review committee. Now, this review committee will go through the document within 7 working days. Okay. So, first is that if there is any emergency, just as I told you before, if there is any emergency with respect to not having access to the proper committee, to the proper agency like Secretary of the Union Home Minister, we do not have the proper access to the person, then the proper information shall be first given in 3 days. It should be, if I wasn't able to contact with the authorized person, I shall give the information after the approval has been garnered in case of emergency to the authorized person in 3 days. Now, after that, in 7 days, it has to be approved. Okay. And this working committee will consist of the cabinet secretary with the law and telecom secretary as members. And in case of the state government, it should be the chief secretary. The committee should have chief secretary and their own respective law and telecommunication secretaries. Okay. And there is also one important fact with respect to this is that the records which are pertaining to any direction with respect to phone tapping shall be destroyed every 6 months. Now, these are important facts from the perspective of prelims. If we talk about transparency, if there is any transparency with respect to it, let's see. First of all, whoever the authorized person is to get the phone tapped, the person or the officer should maintain the specific name and designation of the authority who is doing the phone tapping, who has asked for phone tapping, and the direction in writing by an officer not below the rank of SP or additional SP or equivalent. The person, the officer, should also maintain the records with details of the intercepted call, the person whose messages have been intercepted, whatever the number may be, and the authority to whom the intercepted calls have been disclosed. Okay, so the person whose calls are being tapped, whose phone is being tapped, the person who is doing so, and the person to whom the person is disclosing the facts with respect to the phone tapping should be disclosed, and date of destruction of copies, everything should be contained. So this is transparency. There are certain challenges which have been, of course, talked about before as well with respect to the Indian Telegraph Act 1885. First, the Supreme Court in the Public Union for Civil Liberties versus Union of India in 1996 said that phone tapping is a grave invasion of privacy which is promised under the fundamental right. Article 21 in Justice K.S. Puttaparthi case of 2017, it was said that privacy is a fundamental right. So first that. Secondly, it is said by the Supreme Court itself that yes, although the states do maintain a little bit of surveillance with respect to intelligence operations, but it should be done at the cornerstone of fundamental rights that citizens have. Then legal loopholes are there with respect to having so many open-ended terms, public relation with foreign state, friendly relation with foreign state that I have already discussed. So there are loopholes. Also, it gives rise to authoritarian regime because the citizens are not having any rights with respect to tapping the phone of the central authorities, but the central authority can do so. This gives disproportionate power to the central government, which makes it not democratic but authoritarian. What is the solution? First of all, the basis of a digital economy should be that it should have a data protection law. Any digital economy, if it has to prosper not only from the perspective of economy, I'm not talking about economy, let's talk about a digital country. It should be on the proper patience and proper security of data on the terms of economy, social, political, having the right to freedom of expression under Article 19 and having the right to privacy under Article 21. We have to remove ambiguities and provide proper definition in terms of what is public order, what is public safety, what is friendly relation with foreign state, emergency. Then only if any person's fundamental right is invaded, then the person can go to the Supreme Court or the High Court. There should also be amendment made to the Indian Telegraph Act on what are the morality with respect to phone tapping. So these are the certain things that the legislature has to do. Let's look at the question. How does the Indian Telegraph Act 1885 prove to be a colonial hangover critically analyzed in 150 words? Okay. So that's it for today. Tomorrow we shall meet again with another segment. Until then, stay updated and thank you so much for watching.